call to order the Board of Adjustment meeting for Monday, February 17th, 2025. Chris, please call the roll.
Yes, sir. Todd Cannon.
Here.
Chad McGavery.
Here.
Chairman Sullivan.
Here.
Susan Manette.
Here.
Andrea Beasley.
Here.
Jim DeBovic.
Here.
Next item on the agenda is approval of the November 4th, 2024 Board of Adjustment meeting minutes. Everybody look those over? Any edits, corrections, changes?
I was just curious, has he got the sign put up yet? I know he was waiting to make some changes on the plans to,
We just received the application today.
I make a motion to approve the minutes from the November 4th meeting.
A second.
Any other discussion? All those in favor say aye.
Aye.
Okay, I missed item number 2. Excuse absent board members as necessary. Ethan, out of town, and I knew he would be out of town for this meeting. I think his absence should be excused.
I make a motion to excuse his absence.
A second.
All those in favor say aye.
Aye.
It's passed. Okay, the next item on the agenda is appeal application APP-25-001. Now, note on this meeting is limited to the board hearing arguments from the parties to appeal application and rule upon any appeals or preliminary and evidentiary matters decided by the chair. I think everybody has that paperwork. Prior to opening a quasi-judicial hearing, which will most likely be in March. Okay, with that, a request by Joy and Roy Brownlow for Board of Adjustment to consider an appeal of the Emerald Isle UDO enforcement decision made by the planning director, Mr. Seaberg, and town attorney, I believe that was Mr. Kirby, specific to actions at 330 Live Oak Street. Before I address that, I'm going to name Ty Cannon as the alternate because we have to have only 5 voting members on these types of things. So he'll be the alternate. The other 5 of us will be voting. Okay, I've received a request and reviewed it of the Brownlows' January 14th objection and request for subpoenas to the town's 2025 response thereto. In connection with the appeal of December 13th, 2024 notice of violation pending before the Board of Adjustment. As the chair of the Board of Adjustment pursuant to North Carolina General Statute 160D-406, 1, appellant's objection to the inclusion of the alleged drone photograph of 330 Live Oak Street is overruled. The Criminal Procedure Act by the appellant provides only for the exclusion of such evidence in criminal prosecutions. The statute is NCGS 15A-300.1F. Number 2, the appellant's request to subpoena to Kirby Smith, counsel for the town in this matter, I found unreasonable in nature and therefore denied that. Number 3, the applicant's request for subpoenas to the Commissioner Sawyer, Commissioner Sanderson, Mayor Pro Tem Taylor are irrelevant to the determination of the appeal before this board. Unreasonable in nature and scope, and I therefore denied it. Number 4, request to subpoena Matt Zapp is granted. 5, request to subpoena Chris Seaberg is granted. Appellant's request for subpoena Mark Cruz is granted. Okay. Any questions?
Good evening, Planning Board members and Board of Adjustment members. Thank you for this. My name is Trey Ferguson of the Craven County Bar, along with my colleague Ross Hardiman. We represent the Brownlows in this matter. We are seeking to appeal Chair Sullivan's rulings on our objections this evening, which I believe is what the focus of tonight's hearing will be on. If I can approach, I've prepared hearing binders to kind of outline the issues presented that you all need to address.
That's fine. If you look inside the front pocket of that binder, there is a February 14th letter from the board chair to myself. It was a very nice Valentine. I really appreciate it. Right behind that February 14th letter is the board chair's decision about an issue that we brought up on February 7th, which I'll get to. If you look right behind that letter, there is a 4-page handout that I think mainstreams or outlines the issues presented this evening. There are 3 issues that we are seeking to appeal to the full board this evening. The first one is whether certain board members need to be recused from this matter pursuant to General Statute 160D 109 sub D. The second deals with the chair's ruling as to the exclusion of photographs unlawfully obtained, or what we contend to be unlawfully obtained by the town of Emerald Isle through drone surveillance. And then the third issue is the subpoenas that have been denied in this matter. Just for, as you all know, this is a quasi-judicial proceeding, and so some of my parlance and talk, if you forgive me for the lawyer speech, it's just to make sure we have a good record for any reviewing matter. So for that record, there is a binder that I've prepared with 11 tabs with an index that outlines what is being put before you tonight. It would be our February 7th letter that we sent to the board chair regarding the issues of recusal. It is the town's public notice for February 17th, 2025 Board of Adjustment meeting, which is the notice for this evening that I believe the board chair just read. It is a September 23rd Facebook post. It's the board's rules of procedure under tab 4, the board's rules of procedure as outlined on the website. And I will say that you all are more than welcome to flip through the binder. You don't have to flip through, as I'm just, for the record, putting out there what's been the binder. Under tab 5 is General Statute 160D 109 sub D. Tab 6 is a January 14th, 2025 letter to the board chair regarding the objections on the photographs from drone surveillance, as well as the request for subpoenas. Under tab 7 is the January 20th response from the town on that letter through its attorney from the Carolina Law Group. Tab 8 is the Board of Adjustments Chair's ruling on those objections. Under tab 9 is the December 10th Commissioners Meeting Minutes. Under tab 10 is the notice of violation at issue in this case, issued to my clients. And under tab 11 is a USB of recordings from the December 10th Board of Commissioners meeting, as well as the January 27th Planning Board meeting. So with that administrative stuff out of the way, I'd like to take the first issue this evening, which is whether the certain board members need to be recused from this matter pursuant to the general statutes. So as you all know, a quasi-judicial proceeding is required in a lot of these land use cases because what you're dealing with is property rights, which is protected under the 5th and 14th Amendments
of our federal constitution as well as the law of the land provision of our state constitution. And because we're dealing with property rights, constitutional rights, you have individuals who are seeking relief from a quasi-judicial board that must adhere to due process requirements. Now, when we say due process of law, we're referring to 5th and 14th Amendments of the federal constitution, and again, the state constitution. The two primary requirements of due process are notice and opportunity to be heard on these issues. Specifically, the General Assembly, through the general statutes, has said when you all are sitting as a quasi-judicial board, there are certain times that you would need to recuse yourself. And in those times, it says under 160D, 109D, that a member of any board exercising quasi-judicial functions pursuant to this chapter shall not participate in or vote on any quasi-judicial matter in a manner that would violate affected person's constitutional rights to an impartial decision maker. Now, an impartial decision maker, the statute goes on to say when there is an impartial decision maker and gives a list of examples, specifically relevant to tonight, a member having a fixed opinion prior to hearing the matter that is not susceptible to change. And so if you came in this evening with a certain mindset about my clients, about the allegations of particular ordinance violations, or if you came into this evening's hearing with an understanding of the UDO and what the legal interpretations are around certain provisions of the UDO, and if those opinions are not susceptible to change, the statute does require that you consider that and whether or not you can hear it. It requires you to recuse to preserve my client's constitutional rights to due process. And then another matter would be undisclosed ex parte communications. What that looks like is if you, as a board member, have had conversations outside of this room, outside of this hearing, with a party to the matter that was not disclosed necessarily to the other party. Now, in this case, it's kind of an unusual quirk. You all are the Emerald Isle Board of Adjustment, but you are the judiciary. You're the judges this evening. And you have on one side the Brownlows who are appealing a decision, and then on the other side the town and the town's attorney, Mr. Salato. And so in this case, the town is a party to this lawsuit, to this appeal. And so that, just making clear the roles of everyone when considering whether or not you all have had any type of undisclosed ex parte communications. I also want to point you to tab 4 in the binder, which would be the rules of procedure for the Board of Adjustment. And if you look at the very first red tab under tab 4, the rules of conduct 4-3 and 4-6. 4-3 is essentially the exact same as General Statute 160D 109D, which I read to you all about impermissible conflicts of interest that would create a potential due process violation if you all were impartial decision makers here. But Emerald Isle goes a step further to ensure constitutional rights of its citizens are protected. Under 4-6, it says no board member shall discuss any case with any parties in interest prior to the public hearing on that case, provided, however, that members may receive and or seek information pertaining to the case from any other members of the board. And so this goes a step further to say not just undisclosed ex parte communications, but any type of communications that you have with the party in this case. So any type of communications you might have had with either the Brownlows, my client, or the town and its attorney.
I got a question.
Yes, Mr. Chair.
You're saying that her comment on Facebook is inappropriate?
So that goes into my next point, so I'll get to that point.
Okay.
The two issues.
I got a question.
Yes, sir.
What was the date of that comment?
Yes, sir. So I believe what the chair is referring to is if you look under tab 3, there's a September 23rd Facebook post from a Mr. Jim Normile. showing my client's property, alleged drone surveillance, as well as the address, with a comment by a sitting board member that says, really makes me angry. And again, to protect my client's procedural due process rights, we have to bring this to the full board as to whether or not this would warrant recusal if that individual board member was not able to remain an impartial decision maker, meaning they have had a decision in their mind about the facts of this case and are unable to then put that outside their mind to decide this case. And so that would be the first request on recusal.
And that comment was on September 23rd.
Yes, sir.
When was the, when was the appeal filed?
I'm sorry?
When was this appeal filed?
The appeal was filed in January.
And this happened 3 months before the appeal was even filed?
So I believe this happened while there was ongoing investigations and conversations in the public eye around the facts of this case. And so, you know, an ex parte communication or a decision without hearing all of the facts can be a situation where a member decides a case without ever hearing the additional facts and the opportunity and voicing those opinions. And so this is just bringing it to the record so that you all can make that determination. And again, if that member can put the opinion aside to impartially hear this case, then I don't think there's a conflict, but it is my duty to my client to raise that issue.
Okay.
Should I speak on that?
Have at it. You have every right to speak.
Yeah, so I will say, you know, if you decide that I should not be up here, that is totally fine with me. That comment was made without knowing anything about what was going on, and it would definitely not factor my opinion on this. That statement actually had a broader scope to it than just this situation, and it's like shortly after I put that on there, I wish I hadn't put it on there, to be honest, so.
Well, my point is, that happened months before the appeal was filed. We didn't know there was going to be an appeal.
Yeah, that was
We didn't even know
actually
there was a violation at that time.
that was actually the first I heard about the whole situation. So. But if anybody feels uncomfortable with me being up here, I'm fine recusing myself. So.
No, Mr. Chair, I appreciate your questions, and Member Manette, I appreciate your comments. This is, again, just to bring the issue, put it on the record to ensure that there is no fixed opinion. A fixed opinion doesn't necessarily have to be created once an appeal files. It can be a fixed opinion of the facts as they were developing, which is what I wanted to bring to the board's attention. As for the second issue under 160D, 109D, as whether members have a fixed opinion or any undisclosed ex parte communications, it came to our attention, we gave this to the board chair in our February 7th letter, that on January 27th, the planning board met, and as you all know, that under Emerald Isles UDO, the Board of Adjustment responsibilities are delegated to the planning board. So you all are both planning board members and boards of adjustment members. That letter is under tab 1 of the binder. At that meeting, there was substantial discussions with the town attorney regarding the legal interpretations of sections 2.4.11, 2.412, 6.4, 9.53 of the town's UDO, specifically about the dunes and vegetation protection ordinances. And if you look under tab 1, through the red flags under tab 1, those just cite through the presentation and recommendations that were given by the town attorney at that time to the planning board. Now, this is, again, I acknowledge a delicate scenario, and again, doing my responsibility to put this on the record for the board to make a decision on whether the members present at the January 27th meeting are able to impartially decide the facts and the legal interpretations of this case. And I think that's the important thing, is you as the Board of Adjustment sit as the Emerald Isle judiciary, the judges here. You hear the facts, you read the law, and then you have to make determinations about the legal interpretations of the UDO. And at that January 27th meeting, what was really interesting, and I'm prepared to play it if need be, that at that meeting, there was substantial discussion on what's a dune, what is vegetation, what is natural vegetated area, what is the definition of this? And these were questions posed to the town attorney, who at that time was in an appeal with my clients. And so that's a party getting a 1 month's head start without notice to my clients or opportunity for my clients to be heard on what the legal interpretations are, theories. Because I will tell you, if we get to a merits hearing on this case, the legal interpretations of Emerald Isle's UDO are vastly different. And that's okay, because lawyers, we are used to having difference of legal opinions, and it's for a third party to decide what the interpretation is. But again, the town attorney was given an opportunity in a setting to meet with these many board members who are present tonight to discuss their legal interpretations of the ordinance at issue here. Just because party names weren't mentioned or facts weren't mentioned, those specific provisions of the UDO that we contend the town is interpreting incorrectly and in some cases unconstitutionally, that the town has given an opportunity to submit those to you. And so again, that goes to the members who were here at the January 27th meeting, whether or not that is an undisclosed ex parte communication, but also to the first point, whether they have a fixed opinion on the legal interpretations of the ordinance such that they can't impartially or fairly decide the facts and interpretations of this case.
Okay,
And so,
hold on just a second, okay. We don't really know what the violation is. This board have not seen the violation. We don't know what section of the dunes and vegetation ordinance was supposedly violated. We don't have that information. Discussing that ordinance was certainly, and I was at the meeting. In fact, Chris, didn't we table that discussion?
That's what I was going to say. I thought that was the whole reason we tabled it, is because we didn't all agree on what any of those things meant, and even the
Right.
UDO didn't tell us,
And
so we were like,
didn't know
it's too
how to
nebulous.
know what we discussed as far as specifics about that ordinance, we have no idea if that's your client's, what he's been, got the notice for. We don't even know, we haven't seen the notice. Has anybody here seen the notice violation?
No.
So we don't, how can we talk about the violation when we don't even know what it is?
well, thank you, and I appreciate that question. What I would just submit to the board, that one is my responsibility to raise this issue, present what I believe is a statutory conflict of interest that could affect my client's due process rights, so that you all can make a determination as a board whether or not that is going to be a statutory conflict or a conflict with your rules. And if you look at that handout from February 14th, or the letter from February 14th, signed by the board chair, as well as tab 8, which is the Board of Adjustment Chair's decision on all of these issues. These are the decisions being appealed to the full board. These are decisions that the board chair made about recusal, as well as the other issues which we'll get into regarding drone surveillance photographs and subpoenas. But these were all issues that were brought up in written objections as allowed by the statute, so that we could have a record of it. The chair has ruled and denied all of those requests, with the exception of the subpoenas for Mark Cruz, Chris Seaberg, and Matt Zout. And then also overruled the objection as to whether there was a conflict of interest under the statute. And so under the statute, what my clients are entitled to is to appeal the chair's objections, those two objections, to the full board. Now, what I'm asking for in this first issue is whether specific members need to be recused. What is the board's view on whether they need to be recused under 160D109 in light of the ex parte communications that occurred at the January 27th meeting? And so with that, I would ask that you evaluate that and determine as a board, after the town has the opportunity to speak, that you all decide whether or not you were able to hear this case impartially and whether or not there exists a conflict of interest under the statute. And then once we have, I think that's a threshold issue. I think once we get past that issue, we can then move on to the other two evidentiary type issues. So thank you. Again, and I'm happy to answer any questions. And again, it's just the opportunity to be heard, put it on the record, so that we can all move forward in this judicial process. Thank you.
Mr. Caraway? On the recusal, do we vote on each person individually as a board?
First, the town, I encourage you to let the town be heard before you.
Okay, your microphone's not on.
Front, very front, there you go.
Very- Little button is very front.
Yeah, yeah.
It doesn't work for me either. I gotta get somebody else to do mine.
As soon as you walk up, it turns on. Before a vote, I'd ask the town if they'd like to be heard in response.
Yes, we would. So for starters, I think Mr. Ferguson stated it well. If you do feel that you are unable to make a fair and impartial decision, then it would be your duty to recuse yourself. And I think I'll leave it at there, and that will be for you guys to decide on that matter. Now, as for notice, I would point you to, and I believe it's section 11 of this one, was the minutes, actually, no, wherever the minutes that were provided to you, section 9, I believe it is. Mr. Brownlow was in motion to add that very discussion and the presentation that I gave on the 27th to the planning board agenda. That agenda was provided to the public, which stated exactly what would be discussed, and Mr. Brownlow was present at that meeting. So he saw everything that was discussed, and as was mentioned, nothing case-specific was mentioned whatsoever. The legislative process of the state does not stop just because there are active judicial cases going on. Further, it is permissible under law to have the Board of Adjustment be the planning board. You all are allowed to hold multiple roles. And to that, I would say, it is your duty to keep those roles separate. Should you not be able to keep those roles separate, then that would be grounds for recusal, which is up for you guys to decide. However, it is the town's position that Mr. Brownlow has had notice, and if anything, has had the most notice on what would be discussed at the planning board.
Okay, on the recusal issue, I'll start with me. I had nothing, I said nothing, I had no communication about the applicant's notice of violation. Like I said, I still don't even know what the violation is. So I couldn't be discussing that without knowledge of what the violation is. We still have not gotten that information. So I had no ex parte communications about whatever happened in particular. So I will not recuse myself. And if you want me to call on the entire board to vote on that, I'll be glad to do so. And we can do that with each individual. Mr. Caraway?
Mr. Chairman, I think with recusal, first, it always starts with the individual. If the individual feels they should recuse themselves or they have a particular conflict of interest as set forth by the attorneys and in the statute, then they should recuse themselves. And I think we've gone through that process already. For the ones that were at the planning board, there were no voluntarily recusals made. Ms. Monet here tonight addressed that, and there's no voluntarily recusal on her part. So unless there is a change in an individual's position on whether or not they should recuse themselves, perhaps make a motion to, or open to the board of whether it should put to a vote of whether any individual member should be recused by vote, not by voluntary recusal. If that makes sense.
Okay, now, if I recall in your letter, you didn't list Susan Monet to be recused because she was absent from the meeting. But now you want her
Because of the
recused for her
Facebook
Facebook
post.
comment? Is that correct?
Thank you, Mr. Chair. Yes, no, the Facebook issue is being put in the form of an oral motion this evening
Okay.
so that you can rule on it and then we can appeal, or Ms. Monet, as Mr. Caraway has identified, the individual can select on recusal under the statutory guidelines. And if that's the decision, it can be appealed to the full board, and then that's the end of that.
Okay, I'll go back to me. I have no intention of recusing myself over the issue of the planning board meeting on January 27. You two were absent. You're not apt to be recused, so. You were absent, but your recusal is based on a Facebook comment.
Right.
Do you think you ought to recuse yourself, or can you keep that?
I feel that I could be very impartial on that. Like I
Okay.
said, that was written, I wanted to take it down probably a few days after I put it up there, so.
Thank you. Andrea,
I'm good.
you don't think you need to be recused? Jim?
I do not need to,
Okay.
to recuse myself.
Now, what's the next step? We have to vote on that?
Thank you again, Mr. Chair.
Let me interrupt you. I want to ask the town attorney. I'm an alternate, so can I ask questions?
Town attorney, board attorney.
I'm sorry.
There's both of us here tonight.
I can ask questions or no? I just want to know my part as a alternate.
You can participate, in case that you are called as an alternate
Okay.
to sit, but not on the vote.
Okay.
And Mr. Chair, I would recommend, at least opening to the board whether or not anybody would like to make a motion to recuse anybody else for any reason, so that that can be voted on. That way, we've vetted everybody.
Does anybody up here feel like any of these members need to be recused? That's no one, that's a no. I think my answer was very clear in my Valentine's letter to you. That at that meeting, nothing happened that would warrant refusal. And as far as this Facebook comment, I think it's ridiculous because it happened before there was even an appeal. We didn't, you know, she had no knowledge it might come up for an appeal later, and like she said, she feels no reason to.
I appreciate, Mr. Chair, thank you, and we don't need additional explanation. I'm happy to accept the board's ruling and move on. I do just to make clear on the record that individual members were asked about recusal, denied, and then that was appealed, and the full board overruled the objection, so that we can move on to the second objection. Thank you. On the second page of the free handout, it shows the second issue of whether to exclude certain photographs obtained by the town's drone surveillance of the Brownlows property without their consent from the record. Just to give brief background, what we believe the evidence will show in these hearings when we get to the merits, this is a situation where what the town is alleging is a violation of the Dunes and Vegetation Ordinance, specifically that the Brownlows acted outside of their Dunes and Vegetation permit. And part of the basis, what we believe, part of the basis of that violation are these drone photographs of the property, aerial photographs that were taken by the town's drone, with the town's drone operator. So specifically, it's four photographs of aerials of the property that do not necessarily show any type of survey lines, and specifically were done without my client's consent. And so what I would direct the board's attention to, on the handout, I have an excerpt from General Statute 15A 300.1 sub B. It specifically says that except as otherwise provided in this section, no person, entity, or state agency shall use an unmanned aircraft system to do any of the following: conduct surveillance of, and the next highlighted portion, private real property without the consent of the owner, easement holder, or lessee of the property. The next paragraph is a memo that was provided to the Board of Commissioners and published from the town's attorney that says, as a result, North Carolina law prohibits drones from being used to conduct surveillance of a person or a dwelling occupied by a person without the person's consent. Likewise, North Carolina law also prohibits drones from being used to photograph land without the owner's consent. And so the issue here is the town took it upon themselves to enforce its ordinances through drone surveillance without my client's consent. what I would contend likely violates the Fourth Amendment to unreasonable searches and seizures, as I think we all are aware of that provision of the Constitution. But the General Assembly has said in a state statute that you cannot do this type of surveillance without consent of the property owners. Now, the board chair ruling, again, part of this process is we file a written objection with the chair rules on it, and then we have the opportunity to appeal it to the full board. The board's ruling on this, the board chair's ruling under tab 8, specifically the chair ruled that this particular chapter of the general statutes, 15A, deals solely about exclusion with criminal prosecutions. Now, the statute itself, it's titled criminal procedure, but it doesn't actually have any type of applicability or purpose section in the statute, in the chapter, that says it only applies to criminal. But even if that were the case, the town's UDO does provide for criminal penalties in some cases. And so because it provides for criminal penalties, we would contend that this chapter of the general statutes applies, which says that you must exclude unlawfully attained evidence. And that's what we're talking about. Evidence that has been unlawfully obtained should not be used in any proceeding against the person it was unlawfully obtained against, as a central tenet of our Constitution.
Okay.
Allow.
In your letter to me on that issue, you had much of that ordinance in that letter, but you didn't have the entire ordinance. Mr. Caraway, do you have the text of that ordinance with you? Specifically, what I noted was F, the exclusions, I believe it's in exclusions, 15A-300.1F.
Yes, sir, Mr. Chair.
Can you read that out loud or give us a copy?
I don't have copies available, but subject to objection, I can read it from my copy.
No objection.
Okay.
No objection.
Okay. Subsection F of the statute cited, 15A 300.1, reads, evidence obtained or collected in violation of this section is not admissible as evidence in a criminal prosecution in any court of law in the state except when obtained or collected under the objectively reasonable, good faith belief that the actions were lawful.
And so again, while that statute says specifically to a criminal, I do think that, again, because the town's UDO has the ability to enforce criminal penalties, that this would still apply. While the town is not seeking criminal penalties in this particular case, what you all are doing is providing your town administration with a precedent of when they can use these drone photographs. When do they use unlawfully obtained evidence?
In my opinion, and in this letter, you would have a valid point if this were criminal. It is not criminal. The statute clearly states that.
Again, Mr. Chair, the process is you've given me your ruling, and I appreciate it. However, under the statute, I am allowed to appeal that ruling to the full board, which is what I'm doing to protect my client's constitutional rights.
Understand?
Thank you.
My opinion has not changed. Do I need to call for a vote on that?
I'm not finished. I have two more points real quick.
Okay.
Thank you. And so I think, again, allowing evidence that has been unlawfully obtained, which the statute says, I mean, now you'll notice the statute specifically says the prohibitions of when you can and can't use drone surveillance. And that is in the interest of privacy and privacy of persons and privacy of property. And the fact that if you allow the town to use unlawfully obtained evidence, you are rewarding bad behavior. In the legal world, what that's called is the doctrine of unclean hands. When someone comes to the court, in this case a quasi-judicial proceeding, comes to you all seeking judicial relief, they have to have clean hands. The town is seeking to enforce alleged UDO violations with photographs, and only photographs, that were unlawfully obtained. And so we're asking for those photographs to be excluded from the record in this case. Additionally, and I know rules of evidence are fairly loose in a quasi-judicial proceeding. However, in courts, what a court does is weighs the probative value versus the prejudicial value. And what that is how much of these photos are going to help you determine whether or not there were violations. If it just shows an aerial photograph without any surveyed lines, without any property lines, how probative is it versus how prejudicial? And prejudicial meaning, is it going to shock your conscience? Is it going to make you angry at what you see in a before and after picture?
Like my post.
And so in that scenario, that is a prejudicial effect. You have to weigh, are these photographs going to be more probative to your understanding of if there were violations versus the prejudicial effect it's going to have on my clients? And I do believe that you all know the prejudicial effect because you've seen it play out in the public eye in the public courts, unfortunately. And so with that, I would ask that you would pursue it to the statute as well as, what I would contend is the Constitution, exclude these photographs from any determination in any hearing in this matter before this board. Thank you.
Mr. Seaberg, how common is it to use a drone for this type of work?
That is a new resource that's available. Years ago, you weren't using drone footage for that type of information.
I've been getting aerial photographs of properties for decades.
So that's a different thing. So yes, Carteret County GIS does annual aerial photography that is acceptable. Google Street Maps provides their own version taken from public right-of-ways. That is fine, and our understanding is, yes, drone footage is acceptable.
And our pilot is FAA certified and licensed.
Yes, sir.
And if I understand it, he was in the right-of-way when he took this picture.
That is my understanding, but that is.
I would just, again, for the record, object because I believe the chair is providing testimony which is really hearsay testimony, that Mr. Cruz, who is the pilot, could come in before the board and is expected to come into the board at the merits hearing to provide that testimony. And so I think it's an inappropriate exercise to allow this type of testimony on an evidentiary decision. Thank you.
So, Mr. Chair, why don't we just limit it to asking questions that you have and just receiving the information in response thereto.
I have a question for the town. I'm sorry, I can't remember your name.
Trey Ferguson.
Mr. Ferguson brought up that there are things that in the UDO that can be considered criminal. I kind of agree. I don't want to set a precedence going the wrong way with that. So can you kind of give me, and I don't even know if you can, some idea of the criminal aspects that we could?
If I may, I have it pulled up that I could read from the UDO if that would.
I'm fine.
I'll allow.
Under 9.4.3 of the Emerald Isle UDO, pursuant to North Carolina General Statute 14-4, any person, firm, or corporation convicted of violating the provisions of this ordinance, referring to the UDO, shall, upon conviction, be guilty of a misdemeanor and shall be fined an amount not to exceed $500. No fine shall exceed $50 unless the ordinance expressly states that the fine is greater than $50. So again, that is the criminal penalties aspect of it. And again, just because they're not seeking criminal penalties this evening, I do think it sets a very dangerous precedent moving forward.
Well, it kind of sounds like in a way they could have issued a misdemeanor or whatever you call it. I'm not a lawyer at all. So that does concern me about allowing the drone footage, just because that could be setting a precedence we don't want to set.
Mr. Seaberg, on Martin.
So I'll allow you to answer the question, but I would like to address his points after your question, if I may.
Yes, when the applicant gets a permit, whether building permit or doing the vegetation permit, do they not sign it and allow access to their property from town staff? I've gotten many permits, always have to give access.
So for inspection purposes, yes,
Same thing with doing the vegetation permit.
that's correct.
They give you permission to access the property for inspection purposes.
Yes, sir.
Is that something that you're,
I found that it was just recent that to get a permit approved, you have to click on the, I consent the drone footage, or you don't get the permit.
And if I could just speak to that, to that point, it is my understanding, and I would be happy to do it in the form of testimony or be corrected by Mr. Seaberg. It's my understanding that I think this was one of the first properties that used the drone surveillance for ordinance violations or to investigate alleged ordinance violations. At the time, the little checkbox for allowing drone surveillance was not required as part of a permit. That has since been an addition. And we could talk about the constitutionality of that. I don't think this is the appropriate venue. I will say that I do have, and I do not have a full copy for this hearing, so I apologize, but I do have the permit in this case that I've looked through and not been able to find where it, in the permit, grants consent for inspections and certainly consent for drone surveillance. I do believe the statute allows for
In general,
reason.
it grants access. In general, it grants access of staff to inspect.
And so again, under the terms of the permit, in this case, I don't see where it does that. I know under the general statutes, it can allow reasonable access with coordination with property owners. What we're talking about here is a drone surveillance that was not consented to by the property owners in direct violation of state statute.
Trey, what's the date on that permit?
May 16th, 2024.
That's the email permit that was.
I'm sorry. The permit date is April 15th, 2024.
Thank you.
If I may? Yep. So as for the criminal penalties, that is solely dealing with a conviction in state court under this UDO. For the purposes of you guys, this is an administrative appeal, and I would echo what Mr. Sullivan provided in the letter, that statute is what applies when dealing with evidentiary concerns. As you've mentioned, it's inherent within permits to require inspection, to inspect. You can't determine if a permit has been violated if you're not inspecting. So we would absolutely say that the photos are probative of a potential violation and would be very helpful in helping you all determine that a violation did indeed occur. As for the unlawfulness of it, I believe it was lawful. They consented to inspection by way of getting a permit. Did not specify at the time, but it is inherent in EI policy to use these now, and he was aware of that. And I would just echo the same sentiment that was in your letter regarding the admissibility for administrative purposes as opposed to criminal penalties, which would be given in a district or superior court of North Carolina and not by you, the board.
Just like to, as a rebuttal, just put forth the board the what I imagine to be the unlikely scenario that this appeals process has to go through the court system. And in that exercise, the town then decides to levy criminal penalties in this case. But again, I say that to be unlikely, but still a possibility. The greater concern is you have a drone surveillance in violation of the federal and state constitution and in violation of the state law, which the town attorney, after this drone search was done, the town attorney opined in a memo to the Board of Commissioners that those types of searches should not be done without consent. And so what I am asking you is to weigh, is it a probative value for you to see those photos, or is it going to have a prejudicial effect?
I haven't
And
seen
when
them,
you-
so I don't know.
And when you make that determination, you are then setting a precedent by rewarding what I would contend to be bad behavior with a municipality overstepping the grounds of its authority to conduct a search of property through drone surveillance without consent. And so with that, I would ask that you would allow the objection, sustain the objection to exclude the photographs from any hearing on this matter before this board. Thank you.
And if I may, real quick, criminal penalties are reserved for exclusively intentional conduct as per the UDO. And so that would have to be specially pled, which I don't believe it has in this case at this point.
If it did go to criminal court after this, then you could strike the pictures from the case, correct?
That's correct. That would be the appropriate method for there, but this is an administrative appeal.
Right, exactly, okay.
Mr. Caraway, when we discussed this, I guess been a couple weeks ago, the ordinance that they just cited, it gave all kinds of exceptions for, I think the words are like, no substantial criminal intent by flying the drone, different wordings like that. I didn't bring that 50-page file with me. I probably couldn't find it if I did, but as I recall, it has to be a significant violation.
I think we go back to the question of if this is an administrative case, it's not criminal, so we can have the pictures. If for some reason, like you stated, it could become criminal, at that point, they would need to strike that from the evidence pile, correct? Like,
Yeah, that would occur at court, not with you.
right, but it would not follow the criminal case.
I would not opine on that at the moment, but
Right.
in theory, if something were to be excluded, it would be done there, in that, yeah.
In my opinion, I still think I'm correct in overruling that objection to that photograph. Not ever seeing it, I don't know if it would, how it would affect me. I think the point is to be able to look at it and see if there was a violation or not. That's the whole point of the photograph, along with the other evidence, measurements. I don't even know what these photographs show, so. You've got one photograph in this binder, but I can't even barely tell anything from that.
The thing that's making me not sure how I feel about this is what he said about the prejudicial part.
Well, the evidence that we get is supposed to, honest evidence is going to make you decide this case. It's going to prejudice you one way or the other, so to speak. It's going to justify it. Prejudice would be that you've already decided before you saw the evidence. Or what was the other word you used?
And thank you, Mr. Chair. I do believe prejudicial effect is if it's going to have an effect on you, that what I said is shock the conscience. It's going to make you angry. It's going to allow you to not be able to be impartial at that point versus the probative effect of whether or not you can glean from those photographs whether or not there were any violations. And I believe the chair put it perfectly when he said you have one photo in here and we can't tell anything from it. Well, those are the photos. And if you can't tell anything from it, then it has no probative value. And so it should be excluded on that alone. And so I think you take that into consideration along with the violative search.
I take it you've seen the photos?
Yes, Mr. Chair.
And you think they're going to prejudice us?
Chairman, if I may. So what he's referring to, the prejudicial probative balance, is from the rules of evidence, which applies in typical cases and judicial cases in the state of North Carolina and federally. Might I point you to the statute 160D-406, the quasi-judicial procedure statute? That gives the standards of evidence for a quasi-judicial, and if I may read them out loud. Witnesses may present competent material and substantial evidence that is not repetitive as allowed by the board. Nowhere in this statute, and that is section D, does it mention a probative or prejudicial balance. So that would be the standard, and I would ask Mr. Caraway to opine for hearing evidence in this particular case.
Kenny, if I may, if the photos don't have property lines on it, how can we tell what's what anyway?
Well, Mr.
So we're sitting here discussing over photos that has no measurements on it, no property lines on it. They were pertained illegally by the statute. We get right to, go make inspections and stuff, and if we're making that checking that box now, people know about drone footage now, I don't see where we're gonna benefit from looking at the photos.
If I may, sorry, Mr. Chairman, if I may just remind the board, what's before you is an appeal of the chair's objection to excluding the drone pictures from what will become the record that you will consider at the evidentiary hearing. The original objection in writing to you from the appellant was based on statute 15A 300.1, which is there's been discussion about, in addition to oral arguments from the appellant and the town's response thereto. So I think I'd advise the board to recommend not discussing what's in it, but rather should it be excluded and not included in what you were to consider? Or do you believe that, as the appellant has argued, allowing the drone footage in is a violation of this statute or any other due process rights that they have alleged, or is it a different legal standard set forth in the quasi-judicial procedures and interpretations of that Criminal Procedures Act that the town attorney has alleged? So I would encourage you not to get into the details of what's in it, but just put it to a vote by majority of whether this should be excluded as illegal under 15A 300.1 or some other statute, or if those don't apply, or if you feel that it was obtained consistent with a permit and inspection process as argued by the town, then you would allow it in. So I think that's the vote. That's what's before you to be voted on.
So someone needs to make a motion to vote on that, or is the chair?
If there's no more discussion or questions, I would put it to the chair to make a motion.
Well, before I make a motion, trying to decide if we should exclude the photos when nobody's seen them, it's kind of a crazy thing. It might make us angry. They
You
might,
just said it doesn't matter what they are.
right.
It's a matter
I
of whether or
think
not it's been,
I think they're valid.
that was obtained without permission, and whether or not they,
The,
should it be or should it not be allowed?
I still believe that the photos should be allowed as evidence.
Then make a
I
motion.
make a motion that we allow the photos in the hearing based on like in this paragraph, the Criminal Procedure Act cited by the appellant provides only for the exclusion of such evidence in criminal prosecution. This is not a criminal prosecution. It's the other wording in that ordinance. I felt it comfortable that there was no significant violation of his constitutional rights by using this drone. The way I read that ordinance, and I don't have it in front of me, but the intent of that ordinance is to protect people from surveillance and unwanted, like I said, I don't have it right in front of me. It's vacant property, has to be inspected. I don't have a problem with allowing the photos to go forward. So I make a motion that we allow the photographs for the hearing on the appeal. Do I have a second?
I can't vote.
Now what? No one's made a motion to not allow them. What do we do next?
So
Is it my decision?
your ruling was that they would be excluded, and then he is appealing that to the board. And so I apologize if I didn't set it up correctly. But-
He's-
If
He
I may,
I want them included, he does not.
Right, so
But you got to vote.
I believe, and Mr. Caraway can certainly correct me if I'm wrong, but I believe procedurally, in these cases, this is an appeal of the chair's ruling, and then there should be a vote by the board whether to uphold the chair's ruling, and by upholding the ruling, you would be allowing the unlawfully obtained photographs into the record. And that's upholding. If you would reverse, then you would be excluding them. And so I would be asking you to reverse that ruling, and I will ask for a roll call vote if that's permissible, Mr. Caraway.
Is that permissible for a roll call vote to reverse my decision?
I'm not familiar with any prohibitions against it.
Okay, there's a roll call vote on reversing my decision to allow the drone boats to be used in the notice of violation appeal.
Reverse.
Reversed?
Reverse.
Reverse.
It's reversed. I vote, by the way, I'm voting no, not reversed.
Thank you, Mr. Chair. The last issue for this evening is, again, an appeal of the chair's ruling to not allow subpoenas for town attorney Kirby Smith, town commissioners Sawyer and Sanderson, and Mayor Pro Tem Taylor to appear and testify at the hearing of this appeal on March 17th, 2025, or whenever we decide on the quasi-judicial. I don't know if there's going to be a quorum at that, so we'll reserve that for the administrative part of this. Specifically, if you look at page 3 of 4 of the handout I've provided you, General Statute 160D 406 sub E makes it very clear that when you have an administrative appeal, the official who made the decision or the person currently occupying that position shall be present at the evidentiary hearing as a witness. Now, what makes this, and I will acknowledge the elephant in the room, what makes this unusual, it is a sitting town commissioner who this notice of violation was issued to. And so from that, it is my understanding through listening to the comments of Mr. Seberg and Mr. Zapp in open meetings that there was a level of discomfort in making that decision. That decision was then put to the Board of Commissioners in the form of a vote. If you would look, I put this excerpt in your handout. These are the minutes from the December 10th meeting. On the USB drive of the video at 1 hour, 43 minutes, and 13 seconds is when this conversation took place. The full minutes, if you want them, are under tab 9. Specifically, I'm just going to read from this portion at the end of the Board of Commissioners meeting. Town Manager Matt Zapp asked the board for clarification and direction on how to resolve the UDO issues at 330 Live Oak and 7330 Sound Drive, expressing that staff is ready to execute however the board wishes. Obviously, Commissioner Brownlow recused himself, and then Mr. Zapp went on to make certain findings of fact, asking for testimony from Mr. Seberg in that public hearing, or in that public meeting, rather. It was not an evidentiary hearing, but in that legislative hearing. Mr. Zapp asked for a clear directive from the Carolina Law Group in this awkward situation with a seated commissioner, stressing the need for kindness, dignity, and care equitable to all. Attorney Smith stated that there should be a $1,000 fine. Zapp then inquired about guidance for 7330 Sound Drive. Commissioner Sanderson made a motion to request 2 letters regarding violations, and that motion passed 3-1. And that was Commissioner Sawyer, Commissioner Sanderson, and the Mayor Pro Tem Taylor. And so what makes this unusual is the statute requires that the official who made the decision appear before you to testify as to why they made that decision. It is unclear here who exactly made the decision. I believe what the testimony will show you is that Mr. Seberg did some investigation, and then Mr. Zapp used some of that investigation to determine there might be a violation, might not. I think he was also uncomfortable with that. We won't know until we hear his testimony. And then he put it to a vote with the Board of Commissioners. Asked the Board of Commissioners, we will do as you wish, you direct us. After hearing facts, asked the town attorney, is there a violation? And the town attorney said there should be a $1,000 fine. Specifically, the notice of violation, which is under tab 10 in your book, it came from the town attorney, signed by the town attorney, on the town attorney's law firm's letterhead. Now, I'm certainly not, I'm not saying that the town attorney went out, did the investigation, made the determination, and then issued the notice of violation. That, as town attorneys, that would be very unusual to do. And so I don't think Mr. Smith's testimony is that he made the decision. However, I do think it's relevant that his testimony is going to be, what I imagine, is that I acted at the town's direction. The town being the Board of Commissioners, who made the decision that there were violations. At the December 10th meeting, and again, if the board wishes, I can play portions of that meeting where they had this discussion on whether or not there were violations. But at that meeting, Manager Zapp asked specific questions and stated, I am making the following findings of fact. And then asked the town attorney, are these violations? And then said, board, what do you want me to do? And there was a motion, and it passed to send out the notice of violation. And so I would submit that I believe the 3 commissioners who voted in favor of sending the violations were the decision makers here. When I requested a subpoena for them to appear before you to provide that testimony, that request was denied by the chair as irrelevant to whether or not there were violations. But again, the statute says the official who made the decision must appear. And as the town's judiciary, just like 3 branches of government, as the town's judges, you should be able to hear from the decision maker, even if they were stepping outside of their legislative capacity and making that decision. And so what I would, and then the added issue here on the next page from the town's notice for today's hearing, specifically says the decision was made by the planning director and town attorney. And so it just comes down to, we don't know who made the decision. Was it Mr. Seberg? Was it the town attorney? Was it Mr. Zapp? Was it the 3 who voted in favor of sending the notice of violations? The December 10th minutes to me suggest that the 3 commissioners who voted in favor of sending the notice of violations are the decision makers. And so pursuant to the due process safeguards that our Constitution provides in these proceedings, those 3 officials should be subpoenaed to come here to your evidentiary hearing and answer the question, what are the violations? How did you determine them?
Well, correct me if I'm wrong, but the planning director, Chris Spoke, verbally confirmed various UDO violations, these are the minutes, that have been found, so the commissioners aren't going by what he is the expert, so I'm unclear what you're saying.
So typically what happens in these cases, typically you have a planning director or staff who will investigate the alleged violations, and then will, if the violations cannot be cured, or there's an obstinate property owner who won't remedy the violation, then a notice of violation is sent out. And typically what that looks like is the planning director or his designee will send out a NOV. Well, in this case, that didn't happen. The planning director said, here's the facts, as I understand it from my investigation. And the town attorney said, well, based on those facts, I think you need to fine them $1,000 and send an NOV, say there's a violation. And then the manager put it up to a vote at the Board of Commissioners. And so you kind of have to ask yourself, if the Board of Commissioners hadn't voted, what if they voted no? If they hadn't have voted, yes, send the NOV, would the NOV have gone out? Would we be here? And the answer is no. They being the town attorney and planning director, submitted the NOV to my clients at the direct vote of the Board of Commissioners. And so what I am saying is those 3 commissioners who voted in favor of sending a notice of violation, they found the violation based on what they heard in that December 10th meeting. And they are the one who is the official who made the decision, which under the statute has to be present for this evidentiary hearing. And so with that, I would ask that you would reverse the chair's ruling to not allow the subpoenas against those 3 commissioners and the town attorney. Thank you.
Thank you, Chair. So, as Mr. Ferguson has pointed out, and under the UDO, the official who makes the decision or currently occupies that position is Mr. Seberg as planning director. That is specified in the UDO. Now, it is also the role of the town manager to see through to the enforcement of all the ordinances of the town. And in that capacity, Mr. Seberg is his subordinate. So they are both tasked by the UDO with enforcing it. Nowhere is the town attorney mentioned in the UDO. Now, the vote that occurred in December was who should issue the notice of a violation. Mr. Seberg had already determined that a violation had occurred, and given the delicate nature of an active commissioner being the one who it's enforced against, wanted the board's guidance as to who issues the notice of violation. The determination had been made by his staff, and him and Mr. Zapp will be able to opine to that when they testify. Mr. Smith, nor any of the commissioners made any findings of fact, did no investigations, and simply voted on who should issue the notice of violation. And then Mr. Smith, in his capacity as town attorney, acting at the board's pleasure, issued that notice as he was directed in that meeting.
Just by way of a brief rebuttal. And again, I have it queued up to play that portion of the December 10th meeting, assuming there's no objection, seeing it's a public meeting that was recorded. I'm happy to play that for you all. But you know what Mr. Salato has said to you is, well, the UDO says this. Well, you're right. The problem is I contend the town didn't follow the UDO here. It went to the extreme measure of asking the commissioners to vote on whether there were violations of the ordinance. And so again, if they voted to send the NOV because of what they believed were violations, they should be held responsible to this board to answer the simple questions of, was there a violation and what were they? And how did you determine that? So again, I won't belabor this point. Again, I'm happy to play it if the board finds that that portion of the December 10th meeting is probative to your inquiry on this appeal of the denial of the subpoenas.
I kind of think I'd like to see it.
I have no objection to it being shown. However, I don't think it's going to show anything more than what's already stated here and what I've stated, in that they simply were wanting to know who is to issue this notice. We've made a determination, said what has been violated. Given the delicate nature of an active commissioner being the one we're enforcing, that is the sole focus of that vote, and that's what was done. But no objection to the showing of the video if you all wish to.
Is this the full, the minutes we have, 2021?
Those are the full minutes from that meeting. Those are not the full, it is not the transcript. It is the minutes that were created to summarize the events. I believe the conversation only takes about 5 minutes. I'm happy to play it from my computer, or if we want to plug it up so that the board can view that. I would ask for IT support in setting it up so I don't break the televisions.
I don't think it's necessary. Do you really need to do that? I don't think it's necessary,
All
Trey.
right. Thank you. I think they decided not to. Thank you very much.
I think the minutes make it clear that the main person who gave the notice violation was Chris Seberg with consultation with Matt Zapp, and they both have agreed to be subpoenaed. The commissioners simply agreed with their decision. They didn't give the notice violation. The commissioners agreed with the decision of Matt Zapp and Chris Seberg and voted to tell them yes, give them this violation.
Thank you, Mr. Chair. I think it then goes, the way you've characterized it speaks to my point that the commissioners directed them to send the NOV. They asked and specifically said, staff is ready to execute however the board wishes. And the fact that they voted to send it says that they believed there were violations, so they made a decision. How they came to that decision, they can tell the board when they come here to testify. But I do believe due process requires that the decision maker, whoever it is, appear before you to answer the questions so that it helps you all determine whether or not there are violations.
And Chair, if I may, the decision at vote was, should the planning department send the notice or should the town attorney send the notice? They had made the determination that a violation occurred. The board did not have leeway as to make that determination. They were simply deciding who is sending the notice.
And I
How
object to that characterization because the motion, as put in the minutes that were adopted and voted on by the board, says Commissioner Sanderson made a motion to request 2 letters regarding violations at these addresses from Carolina Law Group on Carolina Law Group letterhead, barring any other notification, and they voted in favor of it. They directed them to send out the violations or the notice of violations.
Not unusual for lawyers to prepare these kind of notices, is it?
We act at the request of the board, so if the board does wish us to, then it would be well within our scope too.
But you don't make those decisions. You are asked to do legal paperwork, and that's how you respond, by writing the notice as directed by the planning director or the
In this case, the board, yes.
Commissioners don't dictate to you what the violation is.
No, sir.
Okay.
Nor did the commissioners make a determination as to what the violation was.
Right, I understand. Now what?
Characterization of the minutes, I would ask that the board, I would request that you all watch the portion of the December 10th commissioner meeting when they are discussing this, because I do think it is relevant. If there's a question of, are they directing them to send out the note? Who are they directing to send, or are they saying there are violations? And for the record, I'm happy to stipulate that the town attorney did not make the determination. However, that he acted at the express direction of the Board of Commissioners, which is what I think Mr. Salata was saying. And again, if he's acting at the direct direction of the Board of Commissioners, those board members who voted in favor should explain why they made that directive to send out the notice of violations.
I would just be repeating myself.
Okay. We've got Matt Zapp is being subpoenaed, Chris Seberg is being subpoenaed. I didn't ask them if they made the decision or not in this setting. But according to the minutes that I read it, and the explanation by Mr. Salata, that it was clear town staff that made the decision. The commissioners agreed and asked the attorneys to write up the violation that the town staff had brought to them. The commissioner did not make the decision, in my opinion.
Are there any other questions from any members of the chair on this issue? Any further questions of either side?
I'll make a motion to uphold your objection.
Motion to uphold.
Except, yeah, to go with what you said.
So a motion to uphold the chair's rulings
Yes.
as to the issuance of subpoenas as it stands.
Yes, as it stands.
Okay.
Is there a second?
I second.
All those in favor say aye.
Aye.
Opposed?
Nay.
You're opposed?
Yeah.
So that's 3-2, that
I would-
Majority upholds.
I would ask, I believe it's the appeal of the chair's ruling, and it seems peculiar the chair would get to then vote on the appeal of that ruling. Is that,
It is peculiar, but that's nothing in the UDO subscribing otherwise. And you'd have to have a majority of 5.
Well, we have an alternate, can he?
No.
Can't vote.
So the vote was 3-2,
He said 1 second.
3-2.
Correct.
The chair's ruling stands, correct?
Correct.
Okay.
thank you all very much for your time. I know these are kind of very dry, procedural, kind of pre-trial type issues, so I really do appreciate it and appreciate you being engaged through the process. Thank you. I believe that's all on this matter for the appeals. I think the attorneys can then communicate the administrative scheduling to make sure we have a quorum at the next merits hearing.
Yeah, with that said, the next meeting is scheduled for March 17th?
March 17th.
17th.
Correct.
And that's St. Patrick's Day? With a name like Sullivan, I gotta be here?
I would move that y'all go out for beers after.
How about,
We'll need that.
No objection.
We'll need that.
Green beer for everyone.
or we serve beer in here?
I don't think your attorney would advise.
I would not advise that at all, actually. If there's no further business, Mr. Chair.
Any further business?
No, sir.
With that, do we have a motion to adjourn?
I make a motion to adjourn.
All those in favor say aye.
Aye.
Second it, right?
Second, I second it.
Second and
Aye.
We had 4 seconds and 5 yeses.
Member Manette seconded.
I'm waiting.
His first.
Do
Meeting
we,
adjourned.
do we